I'm going to leave it set at $100. All right. Have a good evening, ma'am.
Thank you.
All right. Do we have counsel on the phone for Mr. Plyler?
Yes, Your Honor.
Excellent. All right. Do we also have state on the phone?
Yes, Your Honor.
All right. Hold on just a second. Let's get Mr. Plyler in here. Counsel, I was a little premature. I'm going to be honest. They're not here yet. Oh, we've got Plyler. Oh, okay. I'm sorry.
Thank you, Your Honor.
All right. Mr. Plyler, go ahead. Come up to the podium.
Yes.
And counsel, what my practice is I'm going to ask Mr. Plyler to state his name and date of birth, and then I'll let you guys make your appearances. Okay?
Thank you, Your Honor.
All right, Mr. Plyler, go ahead and state your name for the record.
Benjamin Plyler.
All right, Mr. Plyler, what is your date of birth?
June 21st, 91.
All right, and who do we have on behalf of Mr. Plyler this evening?
Benjamin Green appearing on behalf of Mr. Plyler.
And Mr. Green, I'm just going to clarify, I have reviewed your notice of appearance, and you're making a limited notice of appearance for purposes of this initial appearance hearing only. Is that correct?
Yes, I just have to address conflicts and see if the client wants to have me go forward further. That's my standard practice on these cases.
All right, I just wanted to clarify. And who do we have on behalf of the state?
Good evening, Your Honor. Vineet Shaw for the state of Arizona from the Attorney General's office.
All right. All right, Mr. Plyler, you have been charged with sexual exploitation of a minor, a Class 2 felony, and child enticement, a Class 4 felony, with an offense date of May 27th of 2025. Ms. Shaw, would you like to be heard on probable cause?
Yes, Your Honor. Your Honor, during the period of time between approximately April 1st and May 16th, 2025, the defendant worked at a behavioral health inpatient facility that treats juveniles and adults. The defendant is a behavioral health tech, and he admittedly has access to both wards, the juvenile and the adult ward, and he works with juveniles and adult patients. During this time, the victim was 17 years old and was admitted to the facility. The defendant knew that she was a juvenile victim and that she was suicidal. Obviously, the victim was very vulnerable. The defendant knew all of this. The defendant was involved with the victim's treatment plan and treatment team. The defendant and the victim exchanged phone numbers while the victim was still a patient in the facility, and they communicated subsequently via various phone applications, including Snapchat and SMS text messaging and video calls after the victim was released from the facility. The defendant began asking the victim to send sexually explicit images, including photos exposing the victim's anus and vagina. The victim did send the images, and the images were found on the defendant's phone. There are at least 10 sexually explicit images on the defendant's phone of this victim while she was at the time of being 17 years old during this time frame. The date of offense that is listed for the arrest is one of the dates for one of the photos. So therefore, the defendant used his position of trust to solicit and entice the victim, who was a minor at the time, and during this time period, who was also very vulnerable to send these messages, and then the defendant still continued to possess the images as they were found on his phone subsequent to a search warrant.
All right, thank you, Ms. Shaw.
Sorry, Your Honor, would you like me to just continue and give you a couple of the reasons that we're asking for the bond amount, or would you like me to address that at a different time?
So we'll go ahead and talk about the bond amount in a minute. I wanted to address probable cause first. Mr. Green, would you like to be heard on probable? Would you like to be heard on probable cause?
Yes, Your Honor. I mean, the state argued a number of things that aren't in the Form 4. I'm looking at the Form 4. I'm a little curious about the date of 5/27. They have a range between April 1st and May 16th. That's outside that. Also noted in the Form 4 is that the victim, I don't know how this investigation started, but she factory reset her phone and her laptop and it was taken away, or at least factory reset her phone. So I'm not sure if that means that she was the one that initiated sending the photos or not. There's no admissions from my client that he asked for them. Again, we don't have much information in these types of hearings, but there was indication that some photos were found on his phone, but were they sent from her unsolicited, or were they solicited? That's not clear. There is part of the statute, at least for ARS 13-353-553, receiving such material, but how was it received? People can get on these apps and things can be sent to them. There's no evidence that I see that he sent her anything nude. At least that's not what's written here. But the age of 17 also, I'm not sure of her age now, and I know we probably won't know that, but and the state mentioned also she's released. So was she released at the time when the photos were sent? She may have been in this facility and being seen for suicidal issues, but I'm not sure really the timeline. It's a little unclear from what the state had said. We would ask, it's not clear to me, and the court can make its own decision, that probable cause is there. There's also no evidence of child enticement. She may have been a vulnerable adult to justify the allegation of a class 4, but I'm not sure if she was vulnerable when she left, if that's when this happened. That would make it a class 5. And it seems that she was not willing to share this information if she tried to do a factory reset. So I'd ask you to consider those things in finding probable cause, and then I can address the bond amount. But we would ask for that he be released on his own recognizance or to pretrial services. He doesn't have any prior felonies. There's questions about this case if probable cause is found. He has a home. He lives in Scottsdale with his parents. He has no failures to appear, and he's hired private counsel. Thank you.
Okay.
Your Honor.
Yes, Ms. Shaw.
Sorry, go ahead, Your Honor.
I was going to say, I have heard what Mr. Green has had to say, and I do see from the Form 4 that it appears to have been a course of conduct extending until, at least my reading of the Form 4 is till approximately June 16th of 2025.
Correct, Your Honor.
Based upon the information contained in the Form 4 and having heard the argument of counsel, I am going to go ahead and find probable cause in this matter. Ms. Shaw, I didn't mean to cut you off necessarily. Was there anything further from you on probable cause?
No, Your Honor, thank you. I just wanted to mention that there is a probable cause statement attached to the Form 4, so I wasn't sure that counsel had seen that. But it does address all of the things that he mentioned.
Okay. All right. So for purposes of appointing you an attorney, Mr. Plyler, I understand that Mr. Green's representation is limited at this point. I am going to go ahead and appoint you an attorney. I'm now going to turn to release conditions. I have read and received the state's recommendation. Mr. Green, have you read and received the state's recommendation?
I have not received it, Your Honor.
Okay. So I'm just going to let you know the state is recommending a, well, actually, I'll let you go ahead and then state the state's recommendation, Ms. Shaw.
Thank you, Your Honor. Your Honor, did you also see that the additional information continued that was uploaded?
I have the state's recommendation. I have notice of appearance by Mr. Green. I have a form for addendum, 1A form, Plyler, additional information continued, form for addendum.
That's the one.
Okay. And the form.
The additional information continued. Thank you, Your Honor. I just wanted to verify. Your Honor, as Your Honor knows, but Mr. Green, the state is recommending a bond amount of $150,000 cash only. And Your Honor, would you like me to address the reasons?
Yes, ma'am.
Okay. Thank you, Your Honor. So the victim, well, the reasons for this bond amount request are not only what the state has previously stated on the record, and it is included in the probable cause statement in the Form 4, but in addition, the points that are very concerning are the fact that the defendant used his position of trust as a behavioral health technician to groom and prey upon this victim. He did solicit sexually explicit images to be sent to him, which were then contained on his phone and found on his phone. There are at least 10 images, as I mentioned. They are not just nude, they show explicitly the victim's anus and vagina and various positions. As I mentioned previously, the victim was a minor and was suicidal. So being in a position of trust has to do with all of the concerns that the state has due to the fact that the defendant is still employed in this position, and it gives him access and opportunity to interact with other vulnerable minor females. This investigation is continuing, and there may be other victims, but at this point, obviously, Your Honor only has this information in front of them. The other reasons are that the defendant has an incentive to flee. The charges in this case are incredibly serious. He's facing significant mandatory prison time if convicted after trial, and sex offender registration, lifetime probation. He really doesn't have a reason to stay here based on the fact that he had these images on his phone regardless. They're of a victim that's 17 years old. He possessed the CSAM material. And also that he's previously had an interaction with law enforcement wherein the investigation included facts that he had solicited a minor 16-year-old for sexual acts in the past, and those were actually allegations that it was confirmed that the individual was a 16-year-old. Also of note is that the defendant possessed during as it is mentioned on the additional information, during the search of his bedroom, which was pursuant to a search warrant, the special agents from our office observed that the defendant possessed 3 handguns, an assault rifle, multiple preloaded rifle magazines, and in addition, approximately 1,000 rounds of...
Objection, Your Honor. That is not relevant here. That is not relevant.
It's relevant as to the risk to the community and his flight risk.
Okay. And I understand he's not been. I understand that there was some weapons found. However, again, I am going to focus in setting release conditions on the charges that were charged. So if you could focus on those, please, Ms. Shaw.
Yes, Your Honor. Well, there is a factor.
If you have anything further.
Thank you, Your Honor.
Do you have anything further, Ms. Shaw?
Just one moment, Your Honor. I'm just checking my notes. No, Your Honor, just as I mentioned, is that he has incentive to flee and is facing significant mandatory prison time.
Thank you. All right, Mr. Green, do you have
Yes,
a position?
Yes, I do,
On
Your Honor.
conditions.
I mean, yes, if I may respond. Just because he's charged with this, these are not mandatory prison. This was not of an age under 15 years of age. Just because he's charged with these things doesn't mean he's going to flee. The state is asking for a $150,000 bond on Image's case. There's no touching alleged here. The state has thrown everything out there that they possibly could. This is not a trial. I have no known information about a prior incident. You're using that to skew this court into believing he has a prior history, and that's not been proven anywhere. And I think it's tainted the court. I'm hoping that Your Honor will understand that it's the least onerous release conditions. There can be release conditions also set that he not return to Oasis, even if he still has a job there. He can have restrictions that not have any communication with the alleged victim. Again, we have the alleged victim here setting a reset on her phone. Does she think she's in trouble as well? We don't know. $150,000 for this type of case is ridiculous, in my opinion. It's the least onerous conditions to make sure he does appear. There is no evidence that he's going to flee. And the state is just arguing things that are trying to make this sound worse than it is. And I would ask that the state, that the court consider release to pretrial services or some least onerous bond, a secured appearance bond, so he can be released. He has no priors. I don't know what the state is getting this information from, but they're obviously arguing every possible thing they can. This is not a trial. This is release conditions on a probable cause hearing. So I would ask for something much more reasonable, Your Honor. Again, even with photograph cases, we don't have a bond anywhere near this this amount with I've never seen it before that high. Not even a request. So thank you, Your Honor. We'll leave it to you.
All right, and Mr. Green, I did, and Ms. Shaw, I did hear the arguments. I am not considering the allegations with regard to any victim other than the one that is contained in the present case. I did review and have heard arguments. I did review the Form 4, have heard arguments. I actually do think that a bond is appropriate in this case. I am going to go ahead and set 2 hearings in this matter. The first on August 12th at 8:30, the second one on August 14th at 8:30, both in the downtown Maricopa County Superior Court. I am going to go ahead and set a cash-only appearance bond in the amount of $150,000. I do believe that the state's recommended bond amount is appropriate in this case, as well as the type of bond in view of the fact that the victim was, because of the nature of the relationship and the fact that this was a person known to the defendant. I am also going to require electronic monitoring. In addition, you may not return to the scene of the alleged crime. You may not contact the alleged victim. You may not have any contact with any minors. I don't believe, are you a parent, sir?
No.
Okay. So no contact with any minors. You may not access the internet except for court, work, and school purposes only. And full release conditions will be in the paperwork, which the officer will give to you. And with that, I think that concludes this matter, unless there's anything further from you, Ms. Shaw?
No, Your Honor, thank you.
Anything further from you, Mr. Green?
The only thing I'll ask is for re-clarification. This is cash and we cannot have a secured appearance bond, Your Honor?
It is a cash-only appearance bond, yes.
All right. Great.
All right. All right, thank
Your
you
Honor.
so much. And this concludes this matter. So you can go ahead, step to the left. Officer has your paperwork. All right, Carlos Godet, please. All right, sir. Go ahead, state your name for the record.
Carlos Alberto Godoy.
And what is your date of birth?
12/4/96.
Thank you. All right, you are here this evening because the Maricopa County Superior Court issued a warrant for your arrest. I'm sorry, the grand jury in Maricopa County issued a warrant for your arrest on allegations that on or about July 17th of 2024, you committed the offense of sexual exploitation of a minor, a Class 2 felony. That on or about April 18th of 2022 through July 17th of 24, you committed the offense of sexual exploitation of a minor, a Class 2 felony. And that on or about April 18th of 2022 through July 17th of 24, you committed another count of sexual exploitation of a minor, a Class 2 felony. And there are, well, all right, and then on or about April 18th of 22 through April 17th of 24, you committed an additional count of sexual exploitation of a minor, a Class 2 felony, and an additional count on April 28th, 22 through about July 17th, 24, another account of sexual exploitation of a minor, a Class 2 felony, and 2 more counts of sexual exploitation of a minor between the dates of April 18th of 22 and July 17th of 24. Both of those are also Class 2 felonies. I am appointing you an attorney, and I'm sorry, I need to update that. I am appointing you an attorney, and I am setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. I am also setting a cash-only appearance bond in your matter in the amount of $250,000. In the event you are able to post that bond and secure your release, you would be subject to pretrial release conditions, including electronic monitoring, and you may not have any victim contact. All right. I understand that you are currently on probation, so in the event you are able to post those bonds and secure your release, you would need to contact your probation officer within 72 hours. All right, go ahead, step to the left. We are reprinting the paperwork, and we'll get that over to you. All right, we have one house call this evening. Our house call is Myron Clark. I'm sorry, it's Myron Clark. Mr. Clark's date of birth is April 20th, 1988. Mr. Clark is here because the Maricopa County Superior Court issued a warrant for his arrest on allegations that he violated his probation. Hold on. In case CR 2021-00594. And I'm sorry, it's not a warrant, it is a warrantless arrest based upon allegations that he violated terms 1, 2, 3, 4, 5, 7, and 15 of his probation in CR 2021-00594. In that matter, I am setting a secured appearance bond in Mr. Clark's matter in the amount of $500. In the event he is able to post that bond and secure his release, he would need to contact his probation officer within 72 hours. And with that, hold on. With that, that concludes the 8 p.m. initial appearance calendar, and we are going to stand adjourned until 11.